Hello everyone. The topic we will cover today is from section 9 of the Code of Civil Procedure. So section 9, it talks about courts to try all civil suits unless barred. Courts to try all civil suits unless barred. Now see, the word civil, it has not been defined anywhere in CPC. And if you want to understand whether a suit is of civil nature or not, we have to check its subject matter first of all. And on the basis of that, we can evaluate whether its nature is civil or not. Now, to understand civil nature, in section 9, two explanations. Two explanations have been provided in section 9. Now, if you see explanation 1, it says that wherever there is any suit of civil nature, at the time of deciding this, if any questions related to religious and its ceremonies, religious ceremonies, which means like if some questions are there which are related to those questions which are related to religious rites and ceremonies, then such questions can also be incorporated while deciding suits of civil nature, and their nature shall be considered of civil nature, despite of the fact that those religious rites are not purely of civil nature. Which means, if we try to understand explanation 1 in a nutshell, if we try to decide the civil rights, then we can also decide such matters with it which are related purely to religious rites. Which means, if such religious rites and ceremonies are incidentally and collaterally involved with it, with the civil case, with the civil rights, then such issues can be decided by the civil court along with the civil rights. So see, in this very explanation 1, two different rights have been incorporated, have been inculcated. In this explanation 1 of section 9, two different rights have been inculcated: right to property and right to office. It is not like that explanation 1 is only dealing with this two particular rights. Here only an example has been given. Like suppose, if we are determining any right to property or right to office, then while deciding those, the issues which are purely non-civil in nature can also be decided. If those non-civil nature rights are incidentally and collaterally otherwise associated or connected with those civil rights, these non-civil rights can also be decided or can also be considered with the other civil rights in the civil code. Next comes this explanation 2. Now see, explanation 2 is very simple. Explanation 2 is very simple. It says that the right to office that we have discussed now, if no fees are attached with it, or if some fees are attached with it, with that right to office, or if that office is attached to some particular place, or even if not attached with any particular place, then here it will not matter at all if someone wants to decide such right to office in section 9 as of civil nature. So whether or not any fees attached to it, so whether or not any fees attached to, whether or not any place attached to office, it will be of civil nature. On the basis of two explanations given in section 9, in totality, it cannot be decided that whether any matter can be considered of civil nature or not. But we will try to understand what are the cases which are really of civil nature and which are not of civil nature. Perhaps understanding this, we will be able to understand section 9 more clearly. First, let us see those cases which are of civil nature, like all of the matrimonial issues, like divorce, judicial separation, restitution of conjugal rights, maintenance. These are of civil nature. Then the second one is based on contractual transactions, like let's say breach of contract or anything relief demanded uh, on the basis any relief demanded on the basis of contract. Let's say contract, the matters which are related to specific reliefs, civil wrong matters, or if let's say somebody's right to worship is involved. If somebody wants to organize a religious procession, that is right to procession, or otherwise, or other processions like right to burial, right to accounts. If a suit is brought related to accounts, if any suit brought on the basis of let's say partnership, that is suits relating to partnership, even if any religious offices in which some fees are attached or any other offices in which some fees are attached, then in such suits will also be considered to be of civil nature. Or those suits relating to property are also of civil nature, like suppose there is a property and some disputes are there related to its boundaries. Such disputes, such issues are of civil nature. Now let us see those aspects which are not of civil nature, those matters which are let's say purely related to caste. The question of caste is involved, or let's say matter related to elections, matter related to political questions, or matters related to limitation. Like if you want to take some sort of relief and that suit is expressly barred by some law, like law of limitation, let's say, then this will also be considered to be of civil of non-civil in nature. So those matters which are against to public policy, in those cases where the matters related to violation of public policy is involved, those matters are also not considered to be of civil nature. Not considered to be of civil nature. So the examples of suits not of civil nature that we have cited are suits purely relating to caste, suits relating to elections, suits relating to policies, and questions relating to suits barred by law, and also suits against public policy. Okay, thank you.